Good afternoon, folks. It's Thursday, June 12th, 3 p.m. here at the Township Hall in Calabogie. We are going to have our public meeting. This public meeting is held under Section 34 of the Planning Act and is now declared open. The applications on the public meeting agenda today are for public consultation purposes only and will be addressed at a future council meeting. No decisions are being made on these applications today. At this time, I will ask staff to please confirm that the required notice was given for the subject applications in accordance with the requirements of the Planning Act.
Thank you, Mr. Chair. The requirements under the Planning Act are to notify the property owners within 120 meters of the subject properties, and that notification was sent out on May 16th, and required agencies to be circulated under the Planning Act were notified on May 22nd. So those meet the notification requirements under the Act.
Perfect. All those present at the public meeting will have an opportunity to speak in favor of or in opposition to the application. Any and all comments and information submitted, whether orally or in writing, including identifying information, becomes part of the public record and could be made publicly available at any point, including on the Township's website and other electronic forms of publication, in accordance with the Planning Act requirements. Any person wishing to receive the notice of decision regarding any of the applications being considered must send an email request to the Township office immediately following this meeting. And in all cases, said request must be received prior to the date of the decision of council on this matter. Pursuant to the provisions of the Planning Act, the rights and limitations of appeal to the Ontario Land Tribunal with respect to the decision of council on the application are as follows. If a person or a public body would otherwise have an ability to appeal the decision of Township of Greater Madawaska to the Ontario Land Tribunal, but the person or public body does not make oral submissions at a public meeting or make written submissions to the Township of Greater Madawaska before the bylaw is passed, the person or public body is not entitled to appeal the decision. If a person or public body does not make oral submissions at a public meeting or make written submissions to the Township of Greater Madawaska before the bylaw is passed, the person or public body may not be added as a party to the hearing of an appeal before the Ontario Land Tribunal unless, in the opinion of the tribunal, there are reasonable grounds to do so. Additionally, subsection 34(19) of the Planning Act defines the parties that are eligible to appeal the decision to the Ontario Land Tribunal. At this time, I will ask staff to please describe the purpose and effect of the proposed zoning bylaw amendment related to file number ZB2506.5 submitted by Aegis Canada Incorporated on behalf of Jack Stev Holdings Incorporated and summarize any written comments received.
Thank you. So the first application is, as the chair said, for Jack Stev Holdings. The property is in part of lots 4 and 5, concession 13 in geographic Brougham. It's the subject of 3 concurrent severance applications, which were approved by Renfrew County on April 1st. And the application for a zoning amendment on the property is to satisfy a condition of severance for each of those applications. The properties that are to be severed measure between 2.5 and 3 hectares in size, and all 3 lots have direct frontage on and access to flat road. The property is in proximity to lands that fall in the disposal industrial zone in our zoning bylaw, and also in proximity to lands that are zoned extractive industrial reserve. And so in order to support the severances, the applicant retained qualified professionals to do studies to support reductions in setbacks to those 2 zones. And those reports were accepted by the county and reviewed by the township. And so the zoning amendment application that's under discussion today is to reduce setbacks to those 2 zones to allow the development of the lots. So specifically, the property is currently in the rural zone. There is a proposal to create a rural exception 55, a zone on 2 of the lots to permit a reduction from the disposal industrial zone from 500 meters to 190 meters. And then a reduction in the setback to the extractive industrial reserve zone would apply. The setback reduction is from 300 meters to 150 meters. So that's what is being considered today, again, to support the creation of those lots by severance. The only comments we have are comments in writing from our chief building official, who had no objections to the zoning amendment.
Okay, perfect. Does the applicant or the representative wish to speak in regards to the application?
Through you, Mr. Chair, this is Chris Clark with Aegis Canada. I think Tracy did quite a good summary there of the proposal. I just wanted to add, there was some correspondence as part of the zoning amendment about some development that was occurring on the retained lands stemming from these severances, and locating that development in relation to the severed lots to ensure setback compliance. Our office was able to locate that on the sketch that was submitted with the applications to demonstrate that the development that's being constructed right now, or has been constructed, is significantly separated from all of the severed lots. So I just wanted to add that to the discussion. Thanks.
Okay, thank you very much. Does anyone else wish to speak in favor of the amendment? If so, please come forward and state your name and address for the record. Please note that you will have a maximum of 10 minutes to provide your comments. Nobody seen. Does anybody wish to speak in opposition to the amendment? If so, please come forward and state your name and address for the record. Please note that you will have a maximum of 10 minutes to provide your comments. None seen. At this time, I will ask staff to please describe the purpose and the effect of the proposed zoning bylaw amendment related to file number ZB 2506.6, submitted by JP2G Consultants Incorporated on behalf of the Ottawa West Developments Incorporated, and summarize any written comments received.
Thank you. So this application, like the previous one, is coming today as a result of 3 severance applications, which have been conditionally approved by Renfrew County. The property is located in part of lots 12, 13, and 14, concession 7 in geographic Madawaska, has a civic address of 243 Sweets Lane. There are 3 severance applications. 2 will result in the creation of vacant lots, and the 3rd has a dwelling on it, which has that civic address, 243 Sweets Lane. The retained property from that set of severance is over 100 hectares in size. And so the purpose of the zoning amendment, as I said, is to satisfy conditions of severance for each of those applications. There was a requirement by the county official plan to do an archaeological study because the property fronts onto the water. That study has been completed and submitted to the Ministry of Culture. There's a requirement for the ministry to sign off and accept the report, and there's a bit of a backlog there, I'll say, so that sign-off has not happened. So our tool to kind of make sure that development doesn't proceed on the lots until the ministry provides their sign-off is to use a holding provision. So one of the aspects of the application today is to place a holding provision on the 2 vacant lots. It doesn't apply to the lot that has the house on it because that's already developed. So that's one aspect of the application today. A second part is that 2 of the lots have undersized frontage on the private road known as Sweets Lane. One will have 20 meters of frontage and one will have 30 meters of frontage. I will note that the area, the acreage of those 2 lots does exceed the minimum required in our zoning bylaw, but the frontage on the road is a bit deficient. So that's also an aspect of the zoning amendment. And the third part is that the 3 severed lots front to a private road, Sweets Lane. And so we need to place the properties in the limited service residential or LSR zone. So there are 3 kind of aspects to the zoning amendment today. One is the holding provision, one is the recognition of the severed lots on a private road, and the third is the undersized frontage on 2 of the lots. We have received a few comments on this zoning amendment. Ontario Power Generation did provide comments, just noting their ownership fee simple of the shorelands and the water, the bed of the lake abutting, but otherwise they have no objections to the zoning amendment. But they did share that. Our chief building official provided comments indicating he had no concerns with the applications. The third comment comes from Stephen Houlage. I hope I pronounced that correctly. Close enough, thank you. Mr. Houlage has provided written comments which have been circulated to the committee to review, and he's here and will want to speak. But he has requested in writing that the council defer the decision on the application, has expressed some concern with the notification process on the severances from the County of Renfrew, and concern about his ability to get access to his abutting property. So with the chair's blessing, he can perhaps summarize in his own time that the committee has received the written comments that Mr. Houlage has provided.
Perfect. Does the applicant or the representative wish to speak in regards to the application?
Hello, my name is Catherine Curry. I'm a junior planner with JP2G Consultants. I'm joined online today by Anthony Homick, who's a senior planner with JP2G Consultants. And thank you, Tracy, for the report. It was very well done, and we have nothing else to add at this time, but we're available for questions. Thanks.
Okay, thank you very much. Does anybody wish to speak in favor of the amendment? If so, please come forward and state your name and address for the record. Please note that you will have a maximum of 10 minutes to provide your comments. None seen. Does anybody wish to speak in favor of the amendment? If so, come forward. Is that a typo? Oh, my bad here, sorry. Does anybody wish to speak in opposition to the amendment? If so, please come forward and state your name and your address for the record. Please note that you will have a maximum of 10 minutes to provide your comments. I'll go first. Okay, perfect. Just state your name and...
Mike.
Now you might have to hit that mic so the green light is on.
Jesus, that's low. Hi, so I'm Steve Houlai. I own the land bordering 243 Sweets Lane on the east side and the south side through my company, Houlai 1967 Land Corp. I'll just read this because it's simple, but at the same time, if you have any questions after, I'm certainly available. So this land that I own, which used to consist of over 500 acres, it actually had road access. It went across the Madawaska River, and there was a bridge there and a road, and that's how the land was actually, farmed, because it was a large farm. And this was lost, and over 400 acres were flooded, destroying the only road and leaving my land and the adjacent county forest completely landlocked. That same flooding, as I said, has landlocked the county forest. So despite this, the county has previously approved 9 severances on this land without requiring access to be restored, neither to my property nor to the public land, post loss of access through flooding. The county has now approved 3 more severances, conditional on this township rezoning this land. That puts you as council members and this township in a critical position. I am not opposed to severances or development at this site, but only if this long-standing access issue is finally resolved. The county says it has no power, and I've had this discussion yesterday. The county says they have no power under the Planning Act to require an easement over the remaining parcels of property in favor of accessing the county forest for the public good, and they harvest that forest, or to my land, which has 15,000 feet of frontage, and I have no access because of government action to flood the property. So I am completely without access. I cannot get a severance. I cannot build. I cannot use that property safely. It is literally, for all intents and purposes, inaccessible other than by boat. And as we all know, that lake goes up and down 20 feet and it's inaccessible and unsafe to do that in a large part of the year. So the county says it has no power under the Planning Act to require an easement over the remaining parcel, but this is false. I've provided council members, I've provided the planner and the clerk information proving that this is not true. Section 53(12.1) of the Planning Act clearly allows conditions to be placed on the remaining parcels of property for both the severed and retained parcels. And 53(17) says those conditions can still be amended right now, even though the county has actually approved the severance, and it's gone past the days of waiting and it's past the appeal process. Doesn't matter, it has not yet been ascended to be a finished, a finished severance. So right now, this is still possible for the township to push back down to the county to resolve the situation. So access agreements have been upheld repeatedly at the OMB and the OLT, Superior Court, and through other tribunals. It is a fact, and both the county and the township has been provided information and the tools within the Planning Act to ensure this happens. Since August of 2024, I've spoken with over 10 different people at the municipal and county, at the county and the this level, township level here, sent more than 50 emails, met staff on site on my property to consider access points. On August 21st of 2024, I had a 1-hour video conference with the township planning staff from Greater Madawaska and Mr. Randall at EcoView and his staff, which specifically outlined my property's access issues, discussing both the unopened road allowance along the west side of Sweets Lane's property, with the final recommendation that the best way to my property is the property in question at Sweets Lane. That call was recorded. I have that information, I have the communication, and your own planner can attest to the fact that we discussed that the only way into my property that is appropriate is through Sweets Lane. The township was fully aware of this, and was the county, as was the county. However, the county believes that they hold no authority whatsoever to require an easement as a condition of severance. Now that this statement has been proven false, it is incumbent upon you in the township and the planning staff here and this council to right this wrong and resolve this 58-year issue. For the record, I and another abutting landowner, including Steve behind me here, was not provided any notice by the county of the severance application. Furthermore, on November 12th of 2024, I sent a message to Alana at the county saying, I have this property next door. It is a firm closing deal. I wish to have access, and here's my property with a map drawn out. Here's Sweets Lane, and basically inform me if anything comes regarding access or a severance request, because I was going to state under 53, you guys can actually add, enforce, and put an easement on the remaining parcel. Never was I contacted. Yesterday's call with the county, Bruce, can't pronounce his name, Horwath or something like that, he says they don't have the power. They do. Your own planners will know this. The ministry needs to be consulted to confirm whether or not they do or they do not have the right. If they do have the right, this is a public forest without any legal access. This is my land of 15,000 feet, which lost access, which for 50 plus years we've been trying to get access, and now I'm the owner and I've now had 50 emails on the exact topic. The county has failed, and not only have they failed, they are wrong. So I'm not, let me just continue. For the record, here's the thing. The township cannot change this consent. I realize that. It's already been approved. However, you do control rezoning. You literally are here as a body to ensure that the proper planning is put in place, because this is your and our township. There's a forest in our township that has no legal access right now. It's a well-understood problem. The county admits to the problem. I've been through the property with the county staff talking about the problem. The way in is Sweets Lane to the county forest. It is legally allowed and under the Planning Act expected for the public good and for properties just like mine that it get an easement when there is an application for severance. Because I can't just get it from the landowner by going, hey, I need it. Quite honestly, there is mechanisms in place that I could. But the best time to do it is when the landowner who wants the severances wants something, which is the ability to subdivide his property, which in my case is exactly the situation, and that's when you put the easement. So, to approve this rezoning without resolving the access would entrench a decades-long failure, one that could still be fixed. The Planning Act requires you to resolve exactly these kinds of issues. You are not the only holders of rezoning. You are not only the holders of rezoning, you are the safeguards for appropriate planning at your level, at this level, at our level of government. I ask you to refuse this rezoning, pause it, unless the county modifies the severance conditions to secure legal access for my land in the county forest. I place this on the public record and sincerely do hope that the township can resolve this significant oversight done at the county level and ask for your assistance in this matter. It's also required to me that I state that I wish to reserve my right as a person of interest and seek resolution through LT, ombudsman, and courts if necessary, but most certainly I hope I do not need this. As a citizen of this township, I sincerely request this for the forest access, but also my own access. They are indeed equally in need of your assistance, and I thank you for the opportunity to speak.
Well, thanks very much for the words. This,
Can I,
yeah, you want to ask a question?
I would like to, yes.
Sure.
I agree with you completely. I'm curious, since your family property has been there for a long time, do you know where the...
You just bought it, it's 3 months ago.
You bought it, okay.
I just bought it.
So you bought it knowing
So-
it was landlocked?
No, I bought it when it was landlocked, but that's not the point. The right survives the ownership for anything. That is literally why there is a Planning Act and why there are laws put in place to protect land, not the owner.
It shouldn't
So if somebody
be.
inherits property, yes,
It shouldn't be landlocked.
it is landlocked.
Yeah, but
Oh, it shouldn't be.
It shouldn't be.
Well,
It
quite
should never
honestly,
have happened.
quite honestly, when there's 2 surveys done, one was obviously that the Ontario Hydro went, okay, this is a screw up, but they never, first of all, they took the whole island and they didn't need to, and second of all, because it didn't flood, and second of all, they never forced an easement and an access point to resolve hundreds of acres. So it was just insane. But that was back in the 60s. Crazier things have happened. This is 2025. You guys literally hold the key to say no to the rezoning and let it go back to the county. But furthermore, you also must recognize that the county is wrong. They say they cannot put an easement on a severance request. They can. It's been done a million times, and never, ever, ever, ever once has it ever been refused and lost at the township or at the
Okay, we're going to
courts
have
level.
to reel you in
Yeah.
because we're getting way off track here.
So my question is, do you know where the original road was? Because
Absolutely. It's on a map that I sent. The bridge is still there when the water's down 20 feet. I've got maps
So
through the
My
1850s.
understanding, and I have a printout of an old map that shows that was the original, Sweets Lane was the original public municipal road in settler days, so it's been over.
And it went all the way to Madawaska Road.
It went all the way to
Exactly.
Madawaska Road, through that whole area.
Exactly.
And at some point, perhaps it was, a lot
Once
of
a-
these roads are forced roads.
Yep. Once a
So-
road, no, that was built with statute
May I-
labor.
may I-
That wasn't,
may
yep.
I- Yeah. So it was an official road. Somewhere along the line, it got forgotten. And I know there are many properties between Sweets Lane and Madawaska along there that will no longer have access to
Exactly.
their properties from that side, and apparently not from the other side either. So
Yeah.
that's something, for that reason, I think we should not.
It's
but
not a
this is just-
voting,
we're
we're
just
just
an
listening.
information
It's
session
a
here
public
today.
meeting, we are receiving and we're
Yeah.
asking questions, and then council will have the opportunity to review this at the next council meeting.
Right, so we're just hearing right now. So that's why I wanted to make sure I was heard on that
I just
matter.
want to make sure that we're not voting on anything right
No.
now, we're passing an opinion.
Not voting. I think it's important for everyone to know that that road isn't a private road. Sweets Lane dead ends at this point, as far as I can see. There's a gate across.
Which was put in once my landowner was trying to access that land way back.
Right,
That
so
gate.
there are a lot of things that have to be determined before we can go forward to this, and I think the whole growth of Madawaska depends on access to that whole interior property, whoever owns it. So I just wanted to make sure that was understood. As far as the severances, too, my understanding is that they don't have direct access to a road that is maintained year-round. So I don't understand why the county has approved them.
Any more questions?
I appreciate the time. Thanks.
Okay, so this therefore completes our public meeting process for these two applications. Council will give careful consideration to the comments received on the applications before it considers a decision on these applications at the council meeting on June 19th. I now declare this public meeting closed.